All right, good morning, everyone. I'm Judge Jackie Powell, and we are in first appearance court. Today, I am going to let you know whether or not I've determined probable cause, and then we are also going to talk about release conditions. Please keep in mind that today's not your trial date. From here, your case will be assigned to your division judge, where your attorney will be able to file different motions and/or go to trial. And so because of that, I encourage you today not to talk about your case on the record, because everything in this courtroom is being recorded and can be used against you at a later time. If you are represented by attorneys from the Public Defender's Office, I do have an attorney in the courtroom with me, Attorney Brian Reedy, and over at the main jail, there's Attorney Hector Romero. You may speak with those attorneys before attempting to speak on the record. Also, if you are retained by a private attorney, they normally come to the courtroom. They will be able to speak on your behalf, and you may also consult with them before speaking on the record. Please note that we also have in the courtroom the attorney from the State Attorney's Office, Mr. Eric Linder, and other staff, as well as confinement status and pretrial supervision, and the clerk of courts, who of course maintain the records. All these persons are here to facilitate this morning process.
Your Honor, I'm advised they can hear you, but they can't see you.
Okay. I don't know how we fix that. It says it's on. Who can't see me? All right, we'll see how we can fix that.
Paul Ryan, we have you on, Your Honor.
Can you see me?
Yes, that Paul Ryan, I can see you.
Okay, thank you.
Good morning, Judge Powell.
Good.
North Broward.
Good morning. How are you?
I can see you and hear you.
Oh, great, great. And Conti?
I know you're special.
Hello, Conti? Conti, can you verify that you can hear and see me on the screen? I hear no one. All right.
I have all my people at North Broward if you want to do them.
Thank you, Deputy.
I'm ready to go.
Thank you.
I'm not getting an answer at Conti at all. One of those mornings, I guess.
I know. All right, well, let's see how we can do this. North Broward, who do you have? Because then we have to find them on the,
Well, I can tell you the page and where they're at every time.
okay,
Vidal, Christine, page 1.
okay.
Perfect.
Come on, Vidal. Come on, Miss Vidal.
All right, Miss Vidal, good morning.
How are you?
I am well. You are before the court for a misdemeanor capias on a trespassing charge, and the court does find probable cause, and you are represented by the attorney who you can see on your screen, Mr. Shade. What do you wish to do today, ma'am? Do you want to resolve the case, or do you want to?
Yes.
Okay. And the offer then from the city, because it's a municipal ordinance violation, is adjudication and time served. Do you wish to accept that to resolve the case?
Yes, please.
All right, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Ma'am, is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No.
And you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
Yes.
Then what plea do you wish to enter? Guilty or no contest?
Guilty.
All right, I accept your guilty plea, find that it's freely and voluntarily given, and your sentence, ma'am, is adjudication and time served. Good luck.
All right, thank you.
Well, but if they're not at North Broward, it's not gonna help.
I think the second one maybe.
I have a lot of,
Have a seat back in the cell, please.
I have a lot, I only have
6
one
months
more
to pay,
female.
yes. You have,
I only have one more female at North Broward, which is Simran's April on page 5. The rest of my females are either at court or med resets.
how convenient for you.
Listen, my court list was long today.
This is why he works Wednesdays, Judge.
I know, so which one,
I have April Simmons on page 5.
all right. So he doesn't have any of your other persons,
No,
mister. All right,
Unless it was Stephanie Starling, she might be a medical research, I'm not sure.
is, Miss Starling on page 2 a medical reset? Stephanie Starling,
Yes, ma'am, she is.
a medical reset, okay? Stephanie Starling on page 2, medical reset, and, that may be it. Did you have Russell Sweeney on page 12?
No, I don't have him.
Okay, all right, so then we can address April Simmons.
Come on in, Miss Simmons.
All right, Ms. Simmons, you are before the court. Count 1 is possession of drug paraphernalia. Count 2 is felony violation of probation, which is a no bond hold. Count 3 is a felony capias, that's a no bond hold, not for magistrate. Count 4 is a felony violation of probation, also a no bond hold. The court does find probable cause, ma'am, and you do have court with your felony judge tomorrow at 8:30, and I will leave the bond in place on count 1 on the drug paraphernalia at $100. Good luck. All right. Deputy, is that all you have at North?
That's my females. I still have 1, 2, 3, 4, 5, 6, 7 males. I have a Mr. Durden Brandon on page 11.
All right, let me just jump over to the main and see if anything's changed. At the main jail, are you able to see us yet?
Go ahead. No, Judge, I hear you.
Okay, all right, and it's funny, I can see you, but you can't see me.
How am I looking?
Charming as ever.
You're looking great. All right, so let's go back to North Broward, and, all right, who do you have again, Deputy?
Page 11, Mr. Durden Brandon.
Yeah, Mr. Durden would like to resolve this matter this morning.
All right. All right, so on page 11, we have Brandon Durden. Mr. Durden is before the court for a trespassing charge. The court does find probable cause. Does the state have an offer for Mr. Durden?
Yes, Judge, it would be an adjudication and no return to the incident location.
All right, so Mr.
Matt Lopez for
Durden,
the state,
did you,
Judge, sorry.
I'm sorry?
Matt Lopez for the state, I'm sorry, Judge.
Okay, thank you. Mr. Durden, did you hear the offer?
Yeah, but I don't understand what offer though. I hear it.
Okay,
I understand it.
all right. The state would, it was adjudication and time served?
Yes, Judge, that's fine.
Okay. Do you understand that?
Yes, ma'am.
All right, so, and then no return to this location, do you understand that?
Yes, ma'am.
Okay, so you want to resolve your case with that sentence?
Yes, ma'am.
Please raise your right hand, Mr. Durden. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down. Mr. Durden, is anyone forcing you to resolve your case?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
You understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
Mr. Durden, what plea do you wish to enter today? Guilty or no contest?
Yes. Yes.
Guilty or no contest? Guilty means you're saying that you did it, no contest saying I'm not admitting or denying, I just want to resolve this case.
No contest. No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served, and no return to this location. Good luck, sir. All right, Deputy, who else do we have at North Broward?
Page 11 again, Francis.
Mr. Francis's father is here, Your Honor.
Oh, he must have walked out, so we'll wait for him to come back in?
I would guess yes,
Yeah?
if we could.
All right,
Wait for your father to come back in.
all right, all right, who
I
else?
have, I
Correct.
have two on page 15,
Yes.
Royster and Cage.
Yeah.
Are they there?
Yes, they are.
Wow.
Mr. Royster, come on in.
All right, Mr. Royster, you are before the court for trespassing, failing to leave. And the court finds probable cause. All right, were we able to speak to Mr. Royster? Mr. Royster was before the court recently.
It's gotta be divisible ordinance and 3 misdemeanors. Okay, well, when Mr. Shake gets back, oh, he's still here. All right, when we get that case called, we'll see what we can do. Okay, sounds good. Okay, bye.
All right, what do we want to do with Mr. Royster? Or what did he want to do?
I don't know if we have an offer from the state on Mr. Royster at this point.
Judge, the offer would be an adjudication, time served, no return.
So what you wanna do, Mr. Royster?
All right, Mr. Royster, I know these are misdemeanor charges, but I do remember that you were before me recently. So I want to encourage you at this time, wherever it is that you've been trespassed, not to go back there. Do you understand that, sir? All right, sir, please raise your right hand as best you can. Do you swear or affirm to tell the truth? Okay, you can put your hand down. Mr. Royster, is anyone forcing you to resolve your case today?
No.
Are you under the influence of drugs or alcohol?
No.
And sir, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
No.
Have you ever been treated for mental or emotional illness?
No.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
No.
What plea do you wish to enter, sir? I accept your no contest plea. I find that it's freely and voluntarily given. And sir, no return to this location. All right, good luck. Michael Cade.
Hey, come on in.
All right, good morning, Mr. Cade. You are before the court for a trespassing charge. What does Mr. Cade wish to do?
I would like to resolve the case, time served and no return.
Your Honor, state's offer is 15 days in county jail. This is Mr. Cade's 21st arrest in the past year. He refuses to listen to law enforcement officers and judges about not returning to the locations he's been trespassed from.
But if the trespass was already wiped up 2 years ago, how am I still trespassed?
Yeah. And I've also been advised that I cannot send Mr. Cade to a community court. So,
I've already been in 5 days.
Maybe we could send him to Judge Lerner Wren.
I think that's been tried in the past.
Did
Yeah, I
we?
think it has.
yeah. So,
Well, I'd invite the court into the negotiations, maybe if the court consider a
you
better
know,
offer.
I also sent Mr. Cade since to 5 days, I think, the one time, and he complained about that. Then I sent him to community court 2 times. And
But I
then,
didn't have a trespass here.
and and I was advised by community court that he can no longer come back there. So, I think we've all tried our best on, as far as this situation is concerned. So, If Mr. Cade wants to resolve his case, I'm gonna sentence him to 10 days in the Broward County Jail. Either
Did you hear that, Mr. Cade?
Yeah, all right, 10 days it is.
All right, sir, then please raise your right hand.
What? The reason we're right in there is same shit gonna happen, 10 days.
All right, then put your hand down. It's okay. We'll find a probable cause, and Mr. Cade's bond is $25. Okay?
I thought we just said 10 days.
No, sir. You need an attitude adjustment. That's what you need.
Ma'am, you don't understand
Okay?
that I wasn't
Okay,
trespassing.
Mr. Cade, we are done. Deputy, who else do we have?
We have Mr. Huntley Murphy Sherrard, page 18.
Judges, I see you.
All right, we'll come back to you in just a moment.
They've got video at the main jail, Judge.
All right. All right, Sherrod Huntley Murphy. Sir, you are before the court for one count of grand theft auto. The court does find probable cause, I believe it's attempt. It's an attempted,
I think, either it's steal or endeavoring to steal.
okay. All right, so, as to bond, or,
The state has no objection to the bond posted, Judge.
okay.
Can you make $1,000 bond, Mr. Huntley Murphy?
Not this time, sir. I wasn't even in the car. I didn't even go close to the car.
Question was, can you make $1,000 bond?
All right, we'll leave the bond at $1,000.
No, I
Okay,
was saying I ain't got. No, what was he saying?
okay,
I'm just saying-
sir, your bond is $1,000, okay?
He said I can. All right, he said I can at least make like 500. With 500 or $100. I'm ready to negotiate with a bottom sir.
Well,
I'm ready to negotiate.
I am not negotiating. Your bond is $1,000. Mr. Francis, can we have Mr. Francis?
So you drop charge too. That's what I'm saying. I ain't trying to be rude. I understand. I don't.
Listen, can I try to get the guys in and out? That's
But
not
here,
my
she dropped
responsibility.
charge.
Listen, that's yours.
I know you dropped charge too. I appreciate it, Jackie Powell. You dropped charge too. Go ahead, say what you said at the bottom. What you dropped?
Sir, we are done with you. Your bond is $1,000, okay?
Oh, yeah, all right. She dropped too. I appreciate it.
I don't know.
We jumping on board.
Come on, Francis.
All right, Trezal Francis.
The judge is calling you right now, so obviously your father's here. Come on in. He doesn't come here. You're gonna see him on TV. Do you want to come in or not?
That's mine.
Okay, Mr. Francis, you are before the court. Count 1 is resisting officer without violence, and count 2 is refusing to surrender suspended driver's license. Okay? The court does find probable cause, and I will hear from the parties as to bond.
I was going to ask the court for a straight ROR.
Okay,
And the state has no objection to that, Judge.
okay. All right, sir, good morning.
No.
Do you understand what's going on? Okay.
Yes, I do.
All right, so at this time, I will release Mr. Francis on his own recognizance. And he just needs to make sure that he pays attention to the mail so he knows when he has to come back to court. Do you understand that, Mr. Francis?
Yes, ma'am.
All right, good luck, sir.
Yeah, don't miss court, Mr. Francis.
I will not miss it.
All right.
All right.
All right, good luck. All right, we're gonna go back to the main jail.
Yes, Judge.
There are 3 people in the main jail that they have requested to be called out of turn.
Okay,
They are on page 11, Mr. Bailey. Page,
Come on up, please.
page 19, Mr. Macedo. And page 22, Mr. Reed. Reed on 22.
All right, John Bailey. Mr. Bailey's before the court for one count of trespassing, and the court does find probable cause.
Judge, in speaking with Mr. Bailey, he wishes to resolve this matter today.
Your Honor, with respect to Mr. Bailey, the offer would be 15 days. He just got out of jail on the 14th. That's after he was arrested on May 9th for criminal mischief. He pled the charge out to before Judge Levy to time served and restitution. He had a trespass that he pled out May 1st of this year. Also this year, he's pled out battery resisting without violence, trespass, criminal mischief last year, another trespass last year, disorderly conduct. There's been numerous allegations of him destroying property at businesses.
Judge, respectfully, I spoke with Mr. Bailey. He does not wish to accept the state's offer, the $25 bond. From what he informed me, he's homeless. He cannot afford to post that, so we're asking that the court consider releasing Mr. Bailey ROR.
All right, that's going to be denied. Mr. Bailey, I do find probable cause, and your bond is $25. Good luck, sir. All right, Mr. Messidou is on which page? Demetrius, 19. All right. Demetrius Messidou. All right, Mr. Messidou, you are before the court. Count 1 is resisting officer without violence, and then counts 2 through 20 are court order violations that all have no bond holds. So the court does find probable cause. Your bond on count 1 is $100, and you'll be before your division judge shortly, okay?
Judge,
Yes.
our only request is I'm gonna contact the supervisor on our juvenile division to see if we can get a court date as soon as possible on his juvenile cases, but I see here he has a misdemeanor offense. On that case, would the court consider an ROR in that matter?
You mean on the count 1, the resisting without violence?
Yes, ma'am.
Okay.
Yes, Judge.
All right,
Thank you, Judge.
okay. All right, Keo Nataya Reed.
Judge, he's here present?
Okay. All right, Mr. Reed is before the court on, presented as 2 counts of murder premeditated. Count 3 is robbery with a firearm. Counts 4, 5, and 6 are contributing to the delinquency of minors.
And Judge, the first 2 counts should be attempted premeditated murder. And the state is gonna ask for no bond hold on both counts of attempted murder and the robbery firearm, and asking that the court find proof evident presumption grade on all 3 counts as well.
Okay,
And we would object to the court making a finding of proof evident presumption grade at this time. That is the highest standard of proof that we have in the criminal justice system. The state has called no witnesses, produced no evidence. No identification of Mr. Reed has been presented to this court. Furthermore, the state has not produced any type of firearms results or anything along those lines. They have not produced Mr. Reed's post-Miranda statement that he gave. They have not produced any photographs of any injuries of the individuals involved. There's no indication as to the exact age of these juveniles that were allegedly in the car, although I guess that really goes more to counts 4, 5, and 6. So we would, at this time, ask the court not to make a finding of proof evident presumption grade and to set a bond for Mr. Reed.
And Judge, Judge, the state is just asking the court to rely on the affidavit at this time.
all right. In reviewing the affidavit, the court does note that the affidavit indicates that testimony was taken from 3 juveniles who were able to identify the defendant as the shooter of victim 2, and 1 juvenile was able to identify a defendant as shooter to victim 1. In addition, the affidavit does mention that the defendant gave a post Miranda statement that corroborated the story, except that it excluded him as the shooter. Based on the affidavit that's been presented, the court does find probable cause. Further, the court will make a preliminary finding of proof evident, presumption great. This is without prejudice for the defendant to file a motion to set bond with his division judge based on State v. Arthur. And so Mr. Reed will be held no bond on counts 1 and 2. And 3, and then, do we ask for a bond amount on the remaining counts?
In light of the court's ruling over our objection, we'd ask the court to leave the bonds in place on count 4, 5, and 6.
Okay? And so the remaining bonds, standard bonds will remain in place. Okay? All right, good luck, sir. Mr. Shate,
I don't like this one.
is that one that you have left?
Yeah.
Russell Sweeney on page 12, is he in the room?
Okay, yes.
Russell Sweeney, Ramel?
Oh, Judge, I've been advised Russell Sweeney bonded.
Oh, okay.
Perfect.
All right, thank you.
Oh, you write it. Got it.
All right. Teresa French, back at the beginning,
Paul Ryan, I believe.
okay. Teresa French,
Bonded?
all right, she's still sitting there,
Yeah,
so,
yeah, she's at, Paul Ryan on it, but she's, bonding out.
okay. So, Ms. French, just so you know, there are 3 petty theft charges that have been presented against you. The court does find probable cause, and as you've heard, your bond has been posted. So good luck, ma'am.
All right, good luck, Teresa.
Barbara Gissendanner,
Medical reset.
okay. Keone Kimball,
Medical reset.
oh.
So then what do
Marva
They're all
Gentleman,
my North Broward's.
oh, Marva Gentleman is also,
Oh, that's not mine.
okay.
She's main jail, Judge.
All right, Ms. Gentleman is before the court today. Count 1 is fraudulent use or possession of ID of another person without consent. Count 2 is possession of blank or unlawfully issued driver's license. Count 3 is false ID given to a law enforcement officer, and the court does find probable cause. All right, and I'll hear as to bond.
Judge, at this time, nothing to have from the defense.
And nothing from the state.
All right, so the court does find probable cause. Ms. Gentleman has a total bond of $2,100. Okay?
I'll call your sister as soon as I get out, okay?
Elizabeth Bruces.
Come on up, man.
All right, ma'am, you are before the court for count 1, possession of alprazolam. Count 2 is possession of cannabis, 20 grams or less. Count 3 is possession of controlled substance without prescription, and the court does find probable cause.
Judge, Ms. Brizzi contacted her boyfriend. Her boyfriend will be posting her bond. Can we check with confinement status to check, to see if her bond's already been posted or not?
Okay? Okay? It's not been posted yet, or it's not showing yet. All right, do we have Sherry Ann Cavallaro today?
actually was in North, I believe, but I could be wrong.
I think it says North Broward.
Still is, Deputy.
That's another medical reset, and so is Miss Rios, that's next.
Okay, so Ms. Rios is also medical reset. Kara Bruning,
She's at court downtown.
okay. Ms. Bruning is in court. Jermaine Cooley,
Please approach the judge here, Maine. Come on up, sir.
all right, Mr. Cooley is before the court for count 1 is grand theft. Count 2 is fraudulent use or possession ID of another person without consent. Count 3 is possession of counterfeit driver's license or ID. Count 4 is an out-of-state felony hold, and that's a no bond hold out of the state of Virginia.
We're just here on the out-of-state hold, I believe everything
I,
else has been.
yeah, that's what I'm beginning to realize. So really, Mr. Cooley's only here today on count 4, which is the out-of-state felony hold, and it's a no bond hold. So you should be going before the extradition court, shortly, okay? Robert Abt,
Please approach the judge.
sir, you are before the court today, so that I can advise you that you are here on an out-of-state felony hold. The hold is out of the state of Virginia, and the court finds probable cause. It's a no bond hold, and you should be going to extradition court shortly, okay? David Tyson,
Judge, he's approaching, and he declined the services of a public defender.
okay, Mr. Tyson, are you planning on hiring private counsel?
Yes, Your Honor.
Okay, all right, so Mr. Tyson, you are before the court on count 1 is a domestic battery by strangulation. And count 2 is a violation of felony probation, which has a no bond hold attached to it. And you're going before your division judge, tomorrow at 8:30.
Your Honor,
All right, the court does find probable cause?
Your Honor,
Yes.
the state would be seeking a $25,000 bond, pretrial release of the GPS monitor, no victim contact. The state is concerned not only based on the level of violence alleged in this case, but I would note he is on probation for 3 counts of aggravated battery with a firearm, actual possession, 2 counts of shooting, 1 count of shooting into a vehicle, 1 count of possession of firearm by an adjudicated delinquent. I would also advise the court, he was just placed on probation for 4 years, starting on April 19th of this year.
I was placed on probation last year, not this year.
Your Honor, he was sentenced to 364 days in Broward County Jail to be followed by 4 years probation. Going by Odyssey, his probation began in April 19th of this year.
Okay,
No, that's wrong.
all right.
That's definitely wrong.
All right, but you are on probation because you are before the court today for a violation of probation. So if there's a discrepancy as to when it starts, you were still on probation. So the court does find probable cause, and I am going to impose a $25,000 bond on count 1 with a level 2 GPS. And sir, there's going to be no contact with the victims in this case. That means no phone calls, no text message, no social media, no third-party contact. Do you understand that, sir?
Yes, Your Honor.
All right, sir. Good luck. All right. right, Xavier Floyd.
Mr. Floyd, President Judge, I mean?
Sure.
All right, Mr. Floyd is before the court today for one count of aggravated battery causing bodily harm. Count
mind.
2 is domestic battery by strangulation. Count 3 is false imprisonment. Counts 4 and 5 are felony violation of probation. Those have no bond holds, and the court finds probable cause. And I'll hear from the parties as to bond.
Okay. Your Honor, this, okay. Your Honor, the state would be seeking a $50,000 bond on count 1, $25,000 bond on count 2 and count 3, no victim contact, pretrial release of the GPS monitor, no victim contact. This is based on the level of violence alleged in the report. According to the reports, the victim suffered a fractured nose, extreme swelling to her facial area, swelling to her arms, swelling around her front neck. The victim also advised that Mr. Floyd has threatened to kill her in the past. I would also note, as the court can see what he's on probation for, I would also note, since then, 2015, he was convicted of aggravated battery against a pregnant victim and domestic violence by strangulation. That was against the same alleged victim as in this case. In 2016, he was convicted of felony battery due to priors. That was domestic in nature. That was against a different alleged victim. He also had an arrest in 2008 for aggravated battery. That was dropped.
Okay?
Judge, in speaking to Mr. Floyd, I know the state is recommending $100,000 level 2. That's something that Mr. Floyd just financially can't pay. He's been here his whole entire life. He's 29 years old. He is working. He works at BG Group Demolition, where he's been employed with that company for about a year and a half. He's making only about $16 an hour. He does have family that lives in our community. His mom that he would be reaching out to hopefully help him financially, but from what Mr. Floyd advised me, she's not in a financial position to post that monetary bond either. Mr. Floyd is looking forward to contesting these applications and having his day in court and fighting this. But at this time, Judge, I do realize he's being held no bond on counts 4 and 5. I'm asking you to take his financial resources into account in determining reasonable release conditions for Mr. Floyd.
All right, the court does find probable cause, and the allegations in the probable cause affidavit are concerning. And so the court finds that a reasonable bond at this time, count 1, $50,000, count 2, $50,000, count 3, $25,000, no victim contact. That's also going to include a level 2 GPS. And as stated before, Mr. Floyd does have court tomorrow before his felony division judge. Okay? Well,
Judge,
can,
I was explaining to him as far as tomorrow he has a court date. He just wanted to know what room is Judge Al Spector in. Because he wanted to contact his mom to let him know.
I don't have that information at hand.
It's
Do we know?
50, looks like 5870. Yeah.
5870,
Thank you, Judge.
okay? Welken Alexandri.
He's coming up, Judge.
All right, Mr. Alexandria is before the court. Count 1 is domestic battery by strangulation. Count 2 is false imprisonment. The court does find probable cause.
Michelle, do you have any, I know you had something out of state previously. I don't know what happened with it. Well, he was arrested on out of state previously. Like I said, I don't know what happened with it. Your Honor, I'm going to proceed. I don't have anything about criminal history, so I am going to request a $10,000 bond on one, a $5,000 bond on two, noting the allegations, level of violence, and also according to the report, the victim felt it was necessary in order to get away from Mr. Alexandre to jump off the second floor balcony of their residence to run to a neighbor's home.
Okay,
Judge, $15,000 is gonna be something a little bit out of reach for Mr. Alexander's family. He's 25 years old and living in our community for 9 years now. At this time, he's unemployed but looking for employment. He was just working for a construction company where he was making from $60 to $80 a day. Now he's gonna be relying on his grandmother and his sister to help post his monetary bond. That's who he's gonna be living with, his grandmother who lives in an apartment in Miami. My understanding is his grandmother is elderly and I believe is on a fixed income, and his sister works for Publix. So therefore, Judge, I'm gonna ask you at this time on count one to consider imposing a $3,000 bond, on count two, a $2,000 bond. So our total request is $5,000 on Mr. Alexander's behalf.
all right, based on this probable cause affidavit, the allegations are that, over a period of 10 hours, that the defendant forcibly kept the victim inside and threatened to kill her, and dragged her, and then choked her, sometimes for 20 seconds at a time, so many times that she could not count. Then pinning the victim onto a bed whenever the victim tried to flee, and then overnight, the allegations are that she was held so that she could not escape during the night. And plus the allegation that she had to jump from a second floor to escape. And based on those allegations, the court finds that there are concerns for the community, and I am going to impose a no contact order, no victim contact. It means no phone calls, no text messages, no social media, no third party contact. Also, at this time, the court finds that a reasonable bond on count one is $25,000. On count two, $5,000. That's going to include a level 2 GPS. Okay, Andrew Brown. Andrew Brown.
He's coming up.
Here today.
All right, Mr. Brown is before the court for touch or strike, battery, domestic violence. Count two is tampering in misdemeanor proceedings. Okay, the court does find probable cause. We'll hear from the parties.
Your Honor, I'm requesting a $1,500 bond on count one, $1,000 bond on count two, no victim contact.
Okay,
Judge,
Judge, that is reasonable, nothing to add.
All right, so at this time, the court will impose a finding probable cause, $1,500 on count one, 1,000 on count two. And sir, that includes no victim contact, means no phone calls, no cell phones, no social media, no third-party contact. It means no contact. Do you understand that, sir?
Yes, sir. Yes, ma'am.
Okay.
Our only request is, he has belongings at the residence that he's gonna have to retrieve. Can he go one time with law enforcement to retrieve his belongings?
One time with law enforcement, yes, sir. All right, John Thomas?
Come on up, sir.
Okay, Mr. Thomas is before the court for criminal mischief, and the court does find probable cause.
Judge, Thomas, unfortunately, he's not gonna be able to afford to post a monetary bond. We're gonna ask the court to consider an ROR or release Mr. Thomas on pretrial release. He's been living here for over 40 or 64 years old. He gets Social Security. He lives in Pompano Beach with his wife. They've been residing at the same location for about 30 years. The bad thing about it is, unfortunately, when he was arrested, he didn't have his phone with him, so he has no way of contacting anyone. He did tell me he has prior contact with the criminal justice system, but it's about 20 years old, so that's why we're ROR on the alternative pretrial release.
Okay,
Judge, the state would ask that he be released on pretrial.
okay. All right, I am going to grant the pretrial release, and Mr. Thomas, you need to report to the pretrial offices as soon as you're released. Failure to do so will result in a warrant being issued for your arrest. Do you understand that, sir?
I have transportation issues right now. Can I work something out
What does that mean?
with the people involved that I have to report to?
Oh, well, then at this time, as far as resolving the case, you are going to have to, talk with your attorney, okay? But right now, it's in lieu of posting a bond, you're being placed on pretrial supervision, okay? All right, Tony Ehrlich. All right, Mr. Ehrlich is before the court for one count of trespassing, and the court does find probable cause.
Judge Ehrlich wishes to resolve this matter today.
Your Honor, state's offers 15 days. Mr. Ehrlich has arrest March 14th of this year, January 11th of this year, December 18th last year, November 14th last year, August 17th last year, July 12th last year, July 7th, July 5th last year, July 3rd last year, June 20th last year, March 23rd last year, March 21st last year. And what all these arrests have in common is every single time he's arrested at this Home Depot, law enforcement have asked him not to go back. The staff there, judges have asked him not to go back. And he tells judges, yep, I won't go back. He doesn't mean it, he just refuses to stop going back to that Home Depot.
Judge, he doesn't wish to accept the 15 days at this time. He's homeless, so he's requesting the court to release him ROR on pretrial.
All right, that's going to be denied. Mr. Ehrlich is going to have to work with someone to find a location. I sound like a broken record. You have to get help. And so your bond is $25. Kendrick Raymond.
Judge, he bonded.
Okay,
Yeah, Kendrick Raymond. Oh, Judge, he went to the restroom, sorry.
okay. All right, we'll recall him when he's ready. Charles Braxton.
Mr. Braxton.
Come on up, Mr. Braxton. Mr. Braxton's here.
Mr. Braxton is before the court for 2 counts. It's traffic capias, driving while license suspended. This is a capias, the driving while license suspended is a capias from 2016, failure to show at a hearing. And then the second one is capias for not showing at arraignment, operating without a valid driver's license from June 25th of last year. So the court does find probable cause.
Judge, this being Mr. Braxton, who wishes to resolve this matter today.
Okay?
Judge,
Yep.
count 1, the offer would be a withhold court cost. Count 2, an adjudication court cost.
Okay?
He wishes to accept the state's offer, Judge.
All right, Mr. Braxton, do you understand the offer that has been extended to you?
Yes.
And you wish to accept that offer?
Yes.
Okay, sir, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Please state your name for the record.
Charles Braxton?
And Mr. Braxton, do you understand everything that is going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Is anyone, do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
And you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
What plea do you wish to enter, Mr. Braxton?
Okay.
I accept your no contest plea. I find that it's freely and voluntarily given. Count 1, your sentence is a withhold adjudication and court costs. Count 2, your sentence is adjudication and court costs. Okay?
Mr. Raymond is here present, Judge. Go ahead. Come on up, Mr. Raymond.
All right. All right, Mr. Raymond, you are before the court for 1 count of trespassing, and the court does find probable cause.
Judge, this being Mr. Raymond earlier today, he wishes to resolve this matter today.
Listen.
Okay.
The state's offer would be an adjudication, no return to the incident location.
All right.
Judge, he wishes to accept the state's offer.
All right, Mr. Raymond, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down, sir. And please state your name for the record.
Kendrick Raymond?
And Mr. Raymond, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you need any more time to speak with your attorney? And, sir, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And, sir, do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right, what plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served, and no return to this location. All right, our court's gonna take a brief recess, and then I'll be back. Okay, we're back on the record. Latavius McCray.
He's here present, Judge?
All right, Mr. McCray is before the court for 2 misdemeanor capious matters. Those are for resisting without violence and driving while license suspended. It looks like Mr. McCray failed to appear for a calendar call on May 13th.
Judge, and speaking of Mr. McCray, Mr. McCray advised me he didn't willfully not go to court. My understanding is Mr. McCray has another pending matter, I believe, in front of Judge Al Spector. And from that, he's also, my understanding, on level 2.
All the cases was on the Al Spector, they never gave me.
And my understanding is, Judge, he went to Judge Al Spector's courtroom on May 13th. He found out he wasn't on the docket, so what he did, he called his bondsman, and his bondsman advised him that his court date was on June 13th. Now, he says he's been on level 2 pretrial and basically been reporting, doing everything what's expected of him. In fact, he said he's been keeping in touch with his pretrial release officer as recently as 2 days ago, Mr. Curtis Show, to make sure everything was going well. Judge, he just simply didn't know that these 2 cases were in front of Judge Brown. Judge, he's living with his father at West Park. He's working in landscaping, but there's no way he's going to be able to afford to pay this $10,000 bond. Judge, considering level 2 pretrial, I'm asking you at this time for the court to consider an ROR on these matters and for him to be placed on level 2 on these matters as well, Judge.
He was already on level 2 on these charges. All he had to do was contact his pretrial, whoever supervised him for pretrial. They could have looked in the clerk system and would have advised him. Wait, oh, one moment, Your Honor. Yeah, they would have advised him of when his next court date was. All he had to do was contact his public defender, who was present at his arraignment on April 30th, and his public defender could have advised him when his court date was on May 13th.
Okay, hold on a moment. Pretrial, is Mr. McCray on pretrial on these misdemeanor charges? Yes, Your Honor. Okay. All right, so then the bond is $5,000 on each count, and he does have court with his division judge tomorrow. Okay? Darrell Yearby.
Mr. Yearby is here.
Sir, you are before the court. Count 1 is operating without a valid driver's license. Count 2 is traffic capious, and the court does find probable cause.
He wishes to resolve this matter today.
All right, both are, the capious is also operating without a valid license, so.
On count 1, the state's offer would be an adjudication time served. Count 2, a withhold.
Okay,
He wishes to accept the state's offer, Judge.
all right, Mr. Yearby, please raise your right hand. Do you swear or affirm to tell the truth?
I do.
Okay, sir, you can put your hand down. Mr. Yearby, you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And sir, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
I'm aware.
All right, then what plea do you wish to enter, sir?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Count 1, your sentence, sir, is adjudication and time served. On count 2, it's withholding court costs. Good luck, sir. Antonio Wilder,
Bonded, Judge.
thank you. Labardo Duarte,
Bonded.
okay? And next we have Bradley Chang Fat.
Judge, he's here present. At this time, we're gonna be waiving formal reading of the charges.
Okay,
And,
all right, then the court does find probable cause as to all 11 counts. And I'll hear from the parties as to bond.
Judge, the state is gonna be asking for a $10,000 bond on each count, a GPS monitor, no possession of any device with internet access, and no contact with minors.
Okay,
Judge, I'm gonna be asking for we don't have an objection as far as what the state said at this time regarding their pretrial release conditions, that they've requested, even the level of supervision. We're just asking at this time for the court to consider a $5,000 bond on each count. That would be, I believe, my math is correct, 55,000. First time being arrested ever in his life. He's a registered voter here in Broward County. He does have family here. He works at Home Depot, been there for about 1 year, and his salary is about like $10.50 an hour. And that is why we're requesting a $5,000 bond on each count.
okay. Well, having reviewed the probable cause affidavit, the court does have cause for concern for the community, and so at this time, the court does find that a reasonable bond on each count is going to be $10,000. That's going to be with a level 2 GPS. No contact with minors, no device where you can have access to the internet, okay? Marcus Jones.
Bonded.
Yes. As to Mr. Jones?
Yes.
He-
I'm showing he bonded on the count, on the theft. Did he bond on the grand theft also?
Okay,
It's your call, Chief.
all right. Lotta McDonald?
Mr. McDonald, come on up, please.
All right, Mr. McDonald, you are before the court. Count 1 is distributing or delivering cocaine. Count 2 is selling heroin. All right, the court does find probable cause. And I'll hear as to bond.
The $7,500 is something that Mr. McDonald's not gonna be able to afford. We're gonna be asking for the court to consider a reduction. We're asking for a $2,500 bond on count 1 and $1,000 on count 2, making a total request of $3,500. McDonald has been living here his whole entire life. He is working, works for a company called Prestige Property Maintenance, where he's been employed there for 4 months, making about $12 an hour. He lives in Lauderhill with his girlfriend. His girlfriend just got a job working at a restaurant as a cashier. Now, they've been renting at the same apartment now for about 4 months, and their monthly rent is about $1,000. They have 4 kids that him and his girlfriend support, and when he spoke to his family, based on all their bills, they believe they can manage to get somewhere in the neighborhood about $350, and hence that is the reason why we're requesting that monetary amount. Now, I do understand he has a record, but my understanding is he's been clean since 2015. So, Judge, I'm asking for a bond reduction.
And Judge, the state is asking that the bond amounts be kept. The defendant has a 2012 possession of cocaine conviction. He has a 2014 resisting without violence, a 2011 burglary, a 2010 burglary of a dwelling, and in 2009, a possession of cannabis.
Your Honor, just to advise the court, the 2012 was a possession of cocaine with intent to sell or distribute. He violated probation and was sentenced to 27 and a half months state prison.
Once you got out of prison, 2015, Judge, he didn't have any clean record.
No charge ever since.
All right, the court finds probable cause. The bonds are going to remain in place. Nicholas Smith.
He's approaching, Judge.
Mr. Smith is before the court. Count 1 is failure to register motor vehicle. Count 2 is driving while license suspended. Count 3 is no proof of insurance. The court does find probable cause.
Judge, we're going to be asking for the court to consider releasing Mr. Smith on pretrial release. He's 27, been here his whole entire life, working, works at a warehouse, been there for about 1 year, making about $10 an hour. He lives in local lockup with his mother. His mother's on disability. They live on Section 8 housing, Judge. His mom's not going to be able to afford to post a bond, so that's why we're requesting pretrial release on this non-violent offense.
Okay.
State has no objection to that, Judge.
All right, so Mr. Smith will be released to pretrial supervision. Sorry, you need to make sure that you report to pretrial, and because failure to do so will result in a warrant being issued for your arrest. I see that your charges are driving while license suspended. I don't know why your license is suspended, but just for your information, coming up June 14th, there is going to be a clinic for people with a suspended license. If you want to attend that to see if you can fix your, whatever the issues are. At the courthouse on June 14th, you have to register for that program. All right, Trayvon Williams.
Mr. Williams, come on up, please. He's approaching.
Mr. Williams, you are before the court for 1 count of grand theft auto. Count 2 is driving while license suspended. Count 3 is grand theft auto. Count 4 is battery causing bodily harm, domestic violence. And count 3 is operating without a valid driver's license. All right, the court does find probable cause.
Is there another probable cause affidavit that I
Yes,
don't
there are
have?
2.
Okay, let me just take a look at the second one, Judge.
Okay.
We're ready to proceed, Judge.
Okay.
Judge, the state is asking that the bonds be, that are set, stay in place. The defendant has a failure to appear from Broward in 2018. He has a, he has an arrest for an aggravated assault with a deadly weapon in 2014, a contempt of court in 2013, a battery in 2013. Sorry, the aggravated assault with a deadly weapon was in 2010, Judge.
All right, count 4.
Judge, and I would also ask for a $10,000 bond on the battery charge.
Judge, I believe if my math is correct, $12,025 bond that the state is asking for is something that Mr. Williams cannot afford. Mr. Williams is self-employed. He does landscaping and irrigation. When weather permitting, he can make about $70 a day. Judge, he lives with his grandmother. Basically, he's been living with his grandmother off and on. That's the only person that maybe financially can help post his bond, but she is on disability. So from what Mr. Williams' advisement, he doesn't think she can afford anything. My understanding, counts 3, 4, and 5, I see those are not in custody cases. My understanding, in speaking to Mr. Williams, this took place several weeks ago, I believe about maybe 2 months ago or something like that. My understanding is that it's his girlfriend, and the same, I believe it's the same vehicle. It's the same vehicle in question as far as count 1. Whenever Mr. Williams and his girlfriend get into an argument, his girlfriend reports the car stolen. My understanding on the not in custody KPS is his girlfriend was trying to contact law enforcement to try and sign a waiver of prosecution or to let them know that she didn't wish to go forward. When they spoke to law enforcement, they couldn't find anything in the system. Judge, at this time, considering he's been here his whole entire life, Judge, I'm asking the court to consider releasing Mr. Williams on pretrial release.
And Your Honor, part of the concern is, you know, not only was he putting the victim in danger by striking her, but striking her while she was operating the motor vehicle, but also putting anyone else on the road in potential danger.
Right. The probable cause affidavit says that the defendant became violent toward the victim by striking her with a closed fist on the side of the head by her right ear as she was operating the vehicle. As a result of the physical attacks by the defendant, the victim almost crashed into a wooden power pole. And then the attacks continued that caused her to stop the vehicle. And when she stopped the vehicle, that the defendant exited the passenger side and came around to the driver's side, continued to hit her on the head, and instructed her to get out of the car during these attacks. Based on these allegations, the court does find probable cause. As to count 4, I am going to impose a $10,000 bond and no victim contact until further order of the court. Asif Khan. Khan was removed. Okay. Jarek Manley.
He's approaching, Judge.
All right, Mr. Manley is before the court for grand theft. The court does find probable cause.
Judge, I'm going to be asking for pretrial before I proceed. I'll see if the state has an objection.
Yes, Judge, we're,
Proceed. Go ahead, Mr. Romero.
In that case, Judge, Mr. Manley's he's 54 years old, been here his whole entire life. He's looking for work right now, Judge. He lives in Dania Beach with his mother. His mother is on Social Security on a fixed income. He's been residing at that location basically his whole entire life. My understanding is Mr. Manley attempted to contact his brother yesterday to try and see if they can come up with the bond amount. As you see, Mr. Manley is still in custody. They weren't successful in their endeavors. Now, Mr. Manley did advise me that he had prior contact with the criminal justice system, but it's been about 2 years that he's been clean and out of trouble. So, Judge, considering his very strong ties to the community, his lack of financial resources, the fact that he's been clean for about 2 years, and that this is a nonviolent offense, that's why I'm asking the court to consider releasing him on pretrial release.
Your Honor, going to be requesting a $5,000 bond. I would note 2016, Mr. Manley had a robbery by sudden snatching. He was sentenced to 18 months in Florida State Prison. He was released September 1st, 2017. He's had nine prior felony convictions, but the most significant I will advise the court of. In 1990, he was convicted of attempted murder in the first degree and sentenced to 17 years in Florida State Prison.
And just so, the allegations here are that the defendant is identified as a habitual cash voucher thief from the Isle Casino after being identified on several occasions, causing a distraction in the vicinity of elderly patrons or gaming machines. And while distracted, the defendant would steal the voucher belonging to the victims, run to the kiosk and cash the winnings and flee the casino. Based on these allegations, the court does find probable cause. The bond will be increased to $5,000. No return to Isle Casino.
Our Spanish interpreter is here, Your Honor.
Okay, who needed the Spanish interpreter?
There is one gentleman in the main jail. I believe on page... Where was he, Hector?
Judge, he's here. Perez, I've been informed he declined.
But what's the last name?
Perez?
Aiden Perez, page 24.
At Aiden Perez.
Adán Pérez, señor.
Mr. Perez, you are before the court today.
Señor Pérez, usted está frente al tribunal hoy
One count of possession of cocaine.
por un cargo de posesión de cocaína.
Count 2 is operating without a valid driver's license.
El segundo cargo es haber conducido sin licencia válida de conducir.
Count 3 is failure to use due care.
El tercer cargo es falta de usar cuidado adecuado.
And count 4 is a violation of misdemeanor probation.
Y el cuarto cargo es haber quebrantado su libertad probatoria de delitos menores.
The court does find probable cause.
Este juez falla de que hay motivo fundado
And your bond on count 1 is $1,000.
y su fianza en el primer cargo son $1,000.
Your bond on count 4 is $5,000.
La fianza suya en el segundo cargo son $5,000.
And tomorrow you will be before your division judge on the violation of probation.
Y por haber quebrantado la libertad probatoria, mañana se presentará frente a su juez de lo penal.
Okay?
¿De acuerdo?
Okay.
All right, good luck, sir.
De acuerdo, suerte, señor.
Is there anyone else who needed the Spanish interpreter?
Yes, Your Honor. 2 cases further down your docket. Julio Reyes Valverde is in North Broward.
Come on in, Mr. Reyes.
Page 24.
Reyes Valverde? Oh.
Yeah.
All right.
Shelby, have anything?
Okay, Mr. Julio Reyes Valverde.
De acuerdo, señor Julio Reyes Valverde.
Sir, you are before the court for 1 count of grand theft.
Señor, usted está frente al tribunal por un cargo de hurto mayor.
And the court does find probable cause.
Y el juez falla de que hay motivo fundado.
And I'll hear from the parties as to bond.
Ahora iré por parte de las partes en cuanto a la fianza.
Judge, I was able to speak a little bit with Mr. Valverde, but there was definitely a language barrier as far as to what he can possibly afford for bond.
Su señoría, yo sí que pude hablar un poco con el señor Valverde. Definitivamente hay una barrera idiomática en cuanto a poder entender qué tipo de fianza podría él prestar.
Mr. Valverde, are you able to post your bond?
Señor Valverde, ¿será usted capaz de prestar una fianza?
Me pusieron una fianza allá de 1,000.
Yes, I got a bond already for 1,000.
But are you okay?
Okay.
All right, I'll hear from the state.
De acuerdo, pero bueno, oiré por parte de la fiscalía.
Judge, either bond or pretrial is fine with the state.
Pues sea la fianza o sea que sea liberado bajo servicios ante juicio, cualquiera de los dos está bien con la fiscalía.
Okay, so then, Mr. Valverde, your bond is $1,000.
De acuerdo, entonces, señor Valverde, su fianza sí son $1,000.
All right, good luck, sir.
Buena suerte, señor.
There's one more person at the main jail, Your Honor.
Okay, who's that?
Mr. Johnny Vaca on page 22.
All right. All right, Mr. Vaca, you are before the court today.
De acuerdo, señor Vaca, está usted frente al juez hoy
One count of operating without a valid driver's license.
por un cargo de haber conducido sin licencia válida de conducir.
Count 2 is unlawful speed in a school zone. That's not for magistrate.
El segundo cargo es velocidad excesiva en una zona escolar. Eso no está frente al juez de magistrado.
And count 3 is an immigration hold. That is a no bond hold.
Y el tercer cargo es donde lo tienen retenido por migración. Este no lleva fianza.
The court does find probable cause.
El juez falla de que hay motivo fundado
And your bond on count 1 is $25.
y su fianza en el primer cargo son $25.
Okay, good luck, sir.
¿De acuerdo?
All right, is there anyone else?
No one else at me.
Okay, thank you.
Thank you, Judge. All right. See you later. Thanks.
Devon Gillian.
He's a person Judge here, man.
All right, sir, you are before the court today for one count of selling cocaine within 1,000 feet of a place of worship or business. Okay, the court does find probable cause.
Judge, in speaking with Mr. Gilliam, we're gonna be asking for a bond reduction. We're gonna be asking that the court consider $1,000 as appropriate power, $5,000 that's currently set. He's been here his whole entire life. He's 24 years old. He's looking for work. In the meantime, he does landscaping off and on whenever weather permits, and he can get about $40 to $50 a day from what he advised me. He lives in Deerfield Beach with his sister. He's been at that location for about 6 months now. His sister is the person that's going to help post his bond. She's a single mother, has 2 kids, and basically she told him all she has is $100, and that's why we're requesting $1,000 bond on Mr. Gilliam's behalf.
Judge, the state is actually going to be asking for an increase in bond to $10,000. The defendant has 2 pending delivery of cocaine cases currently.
What are those cases? What is the case number on those cases?
The first case is 18-9554 CF10A. The next case is 18-9871 CF10A.
And what are the dates of those
I was
arrests?
gonna say, I believe only one of them, one predates the allegations in this case. This occurred in this matter October 6, 2018. On the 9554 case, Your Honor, he posted bond August 2nd of 2018. Let me check the other case.
Oh, I'm sorry, what did you say the date of arrest on that 9554 was?
He posted bond August 2nd.
August 2nd, okay.
In the other case, the 9871 case, actually, I'm sorry, Your Honor, he posted bond on the same date on both cases. So he was out on both cases.
Which bond is he out on, did he post on in those cases?
On the 9871, it was a $2,500 bond. On the 9554, it was a $1,000 bond.
And both of those are drug charges?
Delivery of cocaine.
All right, right, and then on those two cases, 189554 CF10A and 189871 CF10A, the court is going to revoke Mr. Gillian's bond. And as to this new charge, the bond at $5,000. Okay? Yes. Keith Hunter.
Please approach the judge here, man.
If the state can be heard before Your Honor makes any
Okay.
determinations.
Okay.
Count one in this case, Your Honor, should be a possession of a firearm by a convicted felon.
We checked his history, and I don't believe he qualifies as a violent career criminal, Your Honor.
Okay.
He is a convicted felon now, as mentioned in the PC.
Okay. All right. All right, so I will write that in on count one. It's possession of a possession of a firearm.
Thank you, Judge.
By a convicted felon. Hopefully, we don't have to come back to fix it, even though I'm trying to fix it right now.
Probably will.
Okay. All right, so, Mr. Hunter, you are before the court today for count one, possession of a firearm by a convicted felon. Count two, driving while license suspended. Count three, failure to register motor vehicle. Count four, possession of a open container. Count five and six, those are both traffic infractions for tail lights and brake signals. Count seven is a misdemeanor KPS. Count eight is grand theft auto. All right, so the court does find probable cause. Here is the bond.
Judge, I'm sorry.
No, go ahead. Okay.
Judge, I'm requesting on count one, $1,000 bond. On count seven, Judge, I don't know, Mr. Hunter advised me, he believed he took care of that, case. He went to the, I guess, South, Satellite Courthouse in Hollywood and.
Judge Davis.
In front of who?
Judge Davis.
Judge Davis, Judge Michael Davis. He believed he resolved that case.
This is a KPS issued by Judge Hurley on January 8th of this year for driving while license suspended.
Judge Davis.
You memorized the case number?
No, sir, but I got both. My wife.
Okay. I mean, if I have to look it up.
The state's gonna look it up.
I mean, I'll look it up, but as the court mentioned, Judge Davis couldn't resolve this case. It's a 28 case.
Right.
Okay. Mr. Hunter, I believe is referring to 18-15395 TC 40A, expired DL over 6 months, that he resolved January 8th of this year before Judge Michael Davis.
All right.
Judge,
That's what I'm trying to explain to Mr. Hunter. It
Okay.
seems like it's a different case.
Okay,
But in reference to count one, Judge, the reason why I'm asking for $1,000 bond is, Mr. Hunter, he's basically self-employed. Him and his wife go, scrapping for, where, they pick up pieces of, metal and different type of debris, to get, compensation for that. He's 56 years old. He lives in Fort Lauderdale. Him and his wife been living at the same apartment now for about 3 years, in which their monthly rent is approximately $850. And speaking with Mr. Hunter, you do not comment. My understanding is this, I get firearm was one of the things that he found. From what he advised me, it was along with other pieces of debris that he was scrapping, that it didn't work. It was rusted. It was covered with dirt and everything like that. So we believe the inoperable. Judge, considering the circumstances, that's why we are asking for the court to consider $1,000 bond on count one.
Judge, the state's asking for a $5,000 bond. The defendant has a petty theft from 2017. He has a grand theft and a possession of oxycodone from 2015. Another petty theft in 2015, a petty theft in 2009, petty theft conviction in 2008, possession of cocaine and possession of drug paraphernalia, violation of probation in 2004, another theft in 2004. He had a grand theft in 1994, burglary of a dwelling and grand theft in 94, grand theft auto in 94. So at this time, the state's asking for a $5,000 bond.
all right, as to count one, the court's going to impose a $5,000 bond. And then the standard bonds 7 and 8 will remain in place. Okay. Courtney Clark,
Mr. Correct. Mr. Clark, come on up. He's approaching you. Come on up, sir.
Mr. Clark, you are before the court, so I can inform you that you have a parole violation. It does have a no bond hold, and so you will be going before the parole board shortly, okay? Jeremiah Schmidt,
He's here present, Judge again.
Mr. Schmidt is before the court for driving while license suspended. Says third or subsequent offense, the court finds probable cause. Does anyone wish to be heard?
Judge.
Driving while license suspended or revoked. He was just released on the 24th, 2019, the pre-trial supervision. At this time, we are requesting a revocation of his supervision.
So it's the same charge
It's the same thing.
before
It's the
Judge
same
Bailey, and he was released to pretrial on when?
charge. April 24th, 2019.
Okay. All right. So on case number 18-003862 CF10A, for the charge of driving a license revoked, pretrial is asking that this pretrial supervision be revoked, and at this time, the court is going to grant that. And I am going to, there'll be a bond of $1,000. And as to the new arrest for the same charge, he has a bond of $750, okay? Brendan Nims,
Come on up, sir.
Mr. Nims is before the court for a violation of probation. It's a felony violation of probation. It has a no bond hold, and he'll be before his division judge tomorrow at 8:30, okay? And then Kevin Arma Trading.
He's approaching, Judge.
All right, sir, you are before the court, possession of heroin. Count 2 is trespassing. Count 3 is tampering with or fabricating physical evidence. Count 4 is felony violation of probation. That has a no bond hold. And you'll be before your division judge tomorrow at 8:30. The court does find probable cause, and the standard bonds in place, 1 through 3, will remain. Okay? Anthony Prescott.
Judge, I haven't had a chance to speak to him. I'm gonna need he declined? Oh, Judge, he's approaching. He declined.
All right, Mr. Prescott, you are before the court. Count 1 is grand theft of a firearm. Count 2 is possession of a weapon or ammo by a convicted felon. Count 3 is possession with intent to sell, manufacture, or deliver cocaine. Count 4 is disobeying a yield sign. Count 5 is carrying a concealed firearm. All right, the court does find probable cause, and I will hear from the state. Mr. Prescott, do you plan on hiring private counsel?
Yes, ma'am.
Okay.
Your Honor, we're just checking to see when Mr. Prescott was released from state prison.
I released 2017, December 20th.
Okay.
That's, yeah, okay.
Judge, the state's gonna be asking for a $10,000 bond. The defendant was sentenced to over 10 years in prison for 2 robberies with a firearm in 2007,
2006.
2006 or 7.
Okay.
Yes, Your Honor, I want to state that when I was arrested, I was in somebody else's rental car and I was with 2.
Okay, all right, so the standard bonds on 1, 3, and 5 are $1,000, and those will remain. Count 4 is not for magistrate, and count 2, I am going to impose a $10,000 bond, okay? All right, good luck, sir. Terrell Kimball,
Kimball?
I'm sorry?
Should get
He bonded?
Bonded?
Okay. Owain Bradbury,
He's here, Judge, I mean.
All right, Mr. Bradbury, you are before the court. Count 1 is an out-of-county felony hold. That does have a $44,000 bond attached to it out of the West Palm Beach. And then count 2 is a misdemeanor KPS. Count 3 is a misdemeanor KPS. Count 4 is a misdemeanor KPS. And those all have bonds, count 1 and 4. Count 1 is not for magistrate, but counts 1 and 4 appear to be out of Palm Beach County, and then 2 and 3 are Broward. So the court finds probable cause. The bonds that are in place will remain, and you do have court with your misdemeanor judge in Broward tomorrow at 10 a.m. Okay? Philo Little.
Mr. Little is here present, Judge?
Mr. Little is before the court. Count 1 is possession of methamphetamine. Count 2 is possession of THC. Count 3 is possession of drug paraphernalia. The court does find probable cause.
Nothing to add at this time, Judge.
Okay?
And nothing from the state judge.
All right, so Mr. Little's 1,000, 1,000, and 100. Good luck, sir.
I'll call Anthony as soon as he gets Mr. Giron?
Mr. Giron is before the court. Count 1 is petty theft. Count 2 is fraudulent use or possession of the ID of another person without consent. And count 3 is possess or receive or retain stolen credit or debit card. And the court finds probable causes to those 3 counts.
Judge, nothing to add at this time.
Okay? State,
And the state has nothing to add either, Judge.
Mr. Giron has no priors?
He has nothing local. If it's okay with the court, it'd take me about a minute to see if he has.
Okay. He's on probation in Dade for domestic battery.
Domestic battery as of January 29th, 2019.
All right, I am going to increase the bond on count 3 to $2,500. Okay, and then the other bonds will remain in place. John Bellenou.
Good morning, Ron.
Good morning.
Mr. Below declined it.
All right, sir, you are before the court for count 1, possession of THC, and count 2 is possession of drug paraphernalia. And the court does find probable cause. Does the state wish to be heard as to bond?
Judge, the state is fine with the bond that's listed.
All right, sir, your bond is $1,000, okay?
Okay.
All right, good luck, sir.
Can I ask for a reduction or no?
Well, you
Can I ask
can,
for a reduction to up to 500?
you can ask, but at this time, I am going to leave the bond at $1,000, okay?
Okay, no problem.
All right. Jesse McNair, do we
Still-
have him today? He's-
Still on loan.
Okay,
That's it?
that's it,
Thank you,
sir,
Your Honor.
yes.
Thank you.
Yorick Scott,
Still on loan.
still on loan. Anthony Ferguson,
It's a VOP.
North Broward, Your Honor. Come on in, Mr. Ferguson.
oh wow, he still had more at North Broward.
That's me, Mike, too.
Oh, sorry. All right, Mr. Ferguson is before the court. Sir, this is a change of charge. And so the charge has now been changed to burglary, unoccupied dwelling, unarmed.
It's just been filed as a burglary dwelling. The way the booking system works,
Yeah.
it has to be treated as either a burglary of an occupied or unoccupied. The state's information makes no delineation either way. Judge Miranda originally set the bond at 10,000. I can advise the court, the allegations are clear on their face that the defendant's niece, one moment, arrived at her home, found her uncle in the home at the time, so it did become occupied after he committed the burglary.
It's my residence. I live there. That's not her home. I live there. She don't live there. That's my mother's house. I live there. That's my residence. I cannot burglarize my own house.
Okay,
I live there.
Mr. Ferguson, you can spend that time and speak with your attorney about building your defense, okay? At this time, I am going to leave the bond in place, sir, and you'll have more time to talk with your attorney. $10,000.
And what's the charge?
Burglary,
It's just burglary dwelling.
Okay. all right, sir. Joel Valley,
He's at court, Your Honor.
okay. And Morris Thomas.
Spoke with Mr. Thomas, and then he decided not to join us. He's at Paul Ryan.
And
How much bond is the change of charge?
it's a change of charge, Your Honor. Essentially, what happened was, when he was booked, he had the wrong charge put on him.
Okay.
You found proof evident or presumption great for the charge that we filed.
We did?
Your Honor did, yes.
Okay.
It was essentially a sexual battery, making a threat to induced by a threat of physical harm
Okay,
or death. We just added a count it's against the same alleged victim. One moment. To put it, without going into great detail, Your Honor, each count lists a different body part of the victim.
what, so at the first appearance,
You found proof evident presumption great on the one count, ordered him to be held no bond. Your Honor, based on the representation from the state, I'd ask the court keep that, just adopt your previous ruling on count one, and based on your previous ruling, find proof evident presumption great on count two.
so that you know, on mine, I only have one count. You're saying count two?
Do you have, Your Honor, if you look at the capias that was issued,
Okay,
there should be,
oh, well,
I don't know
what
why
should
this-
count two be?
the same as count one.
Because even on the kepias, it's not really clear. It just says,
Your Honor,
it
what
says
it is?
sexual battery, special
If,
circumstances.
if I print you out a copy of the information, would that assist the court?
Sure,
Okay.
thanks.
Which is actually, in fairness to the jail, that's exactly what it does list on the information.
Oh.
But but it goes into more detail describing the offense.
Okay. So there was a finding of proof evident presumption grade on one.
Yes, ma'am.
Okay.
So the way it changes.
Oh, and that's what the information says.
Yeah, yeah.
So on count two, all right,
To see what happened the first time you saw. Usually it's gonna be some kind of technicality.
I think count two is, or no, he's refusing to come, so. All right, so as to count one, we will adopt the previous findings of proof evident presumption great without prejudice. And then on count two, what do we have there, Mr. Linder, on count two?
It's, well, that's an ad charge. It's the same It is the same offense alleged.
Oh,
As you
okay.
can see, the only difference between 1 and 2, it just has to do with,
Okay, all right, so, and then as to count 2,
but Your Honor, I believe the court can rely upon your findings, previous findings, considering it's the same allegation against the same alleged victim.
right?
Right.
I hope this means that he doesn't have to come back,
Yeah, right.
but,
He didn't stick around, so.
I don't know what Mr. Reedy said to him.
Yeah, I have that effect on me.
But on count 2, then I'll adopt the same finding, okay? All right, I believe that brings us to the end of our morning docket. Thank you, everyone, and I'll see you at 1 p.m.
Very good.
Because we can't.